Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, can it be resolved? The use of mediators to settle antitrust class actions. As everybody really knows, most antitrust class action lawsuits settle. But that is not always easy to accomplish. There are a lot of reasons why it's difficult for antitrust lawsuits to settle. It might be a difference in information. It might be differences in expectations. It might be that there are parallel proceedings that are going on that make it difficult to settle one and not the other. But the key point is almost all of them settle. And frankly, most of them should settle, because that is probably the way that we get to the fastest and easiest results. Well, because it's not easy, many times we turn to mediators, folks that are neutral, that can try to help the parties get to a settlement. And there's a group of mediators that really specialize in antitrust law, or who know antitrust law very well at any rate, and are regulars that people go to. Today, we have one of the leaders of the antitrust mediation bar with us today, who's going to talk to us about what are some of the best practices? What are some of the ways that you can use mediators to help settle antitrust cases? My co-host today is Kayla Odom. Hey, Kayla.
Hi, John.
Kayla, what are we doing today?
Well, you talked about mediating antitrust class actions. I'd also hope that we can talk a little bit about, why people should participate in mediation, and are all types of cases suitable for mediation. And if we're thinking about big stakes antitrust class actions, is mediation the common way that those disputes get resolved? Many of us encounter mediation in our careers to solve legal disputes. But, I often hear the sentiment that people are hesitant to participate because they don't want to waste time. They don't want to waste money. But mediation, if successful, it can resolve disputes more efficiently and sometimes in a more flexible way than would be through the courts. So today we're also going to discuss the advantages of mediation, and in particular, mediating antitrust class actions.
Great. Who's our guest?
Our distinguished guest today is the Honorable Judge Vaughn Walker. Judge Walker served on the bench for over 20 years as a judge of the U.S. District Court for the Northern District of California, and served as the Chief Judge from 2004 to 2011. Judge Walker has lectured at law schools in the San Francisco Bay Area and now holds a mediation and arbitration practice in San Francisco. Judge Walker, welcome to the program.
Thank you, Kayla. It's nice to be here. And hello, John.
Hi, Judge Walker.
Judge Walker, why would you say people should consider mediation? And maybe you can answer that question by telling us what brought you personally to mediation.
Well, that's a compound question, Kayla. And what brought me to mediation and arbitration both is after 21 years on the bench, I decided to take off the robe to get on the other side and see if I couldn't resolve cases in a more consensual manner. And that leads to the answer to your other question. Why mediation? The advantage of mediation is that it's a consensual process. The case will not settle unless both sides, or all sides, and often in these antitrust class actions, you have more than two sides, but the case will not settle unless you get the consent of the parties on all sides of the case. And that is, therefore, a more satisfactory way of resolving these disputes than having to go to court and have the matter litigated with the attendant expense of litigation and the uncertainties and risk associated with litigation. I frequently tell parties and lawyers in mediation that if the alternative is going to court and litigating and trying the case, all they've accomplished at the end of the trial is a ticket to the Court of Appeals. So it becomes almost an endless process. And certainty and finality are great advantages of mediation and settlement.
Judge Walker, what is it that a mediator brings that the parties just can't do themselves by talking to each other?
It's a very good question, and it's one that you worry or at least think about frequently, because the parties can do a great deal without a mediator. They can talk to one another, they can understand their respective positions, they can develop a rapport and a dialogue, and a lawyer, particularly in complex litigation such as these antitrust class actions, should not for a moment hesitate to develop that rapport and relationship with the lawyer on the other side. That solves a great deal of problem in an adversarial context, which of course these cases which is where these cases are. So there's a great deal that can be done pre-mediation by the lawyers themselves without a mediator. But what does a mediator bring? There really are two things. A mediator, particularly one who's been experienced in the field, can provide some evaluation of the parties' positions, can give some feedback. Oftentimes that involves giving some bad news to a party, telling the party the risk that it faces in the litigation. In order to do that effectively, the mediator has to develop some credibility with the parties, and the neutrality of the mediator has to be maintained at all times. But still, having a third party who's disinterested in the controversy give an evaluation of what some of the risks and problems are in the case is very helpful to parties evaluating what their prospects are. And the other part of mediation is simply facilitating a dialogue. As much as good lawyers are able to deal with one another, there still are problems. Sometimes it's a client problem. Sometimes there's a relationship that interferes with the ability to work out differences, and a mediator can help facilitate that kind of resolution. So it's both of those functions, and every mediation is inevitably some part evaluation, some part facilitation. Some are more of one than the other, but they inevitably are some of both.
You know, it's interesting because sometimes I think a lot of what a mediator does is he or she helps with the social awkwardness of having the difficult conversations, because you as a lawyer may want to tell the other side they're being completely unreasonable. But if you say that to them, or if you tell them how strong your case is, it all seems like posturing. And a mediator can help an awful lot to sort of deliver a message that you want to deliver to the other side.
It's very true.
Judge Walker, I mean, what's your view on that? Is that something a mediator does?
A mediator does that, and does a lot more than that. One of the things, too, a mediator can do is to get the parties on track to thinking about how the case is going to settle, to essentially require settlement term sheets as part of the mediation statement, to get the parties focused on an outcome rather than simply on the respective contentions that they're asserting. One of the mistakes that lawyers sometimes make in mediation, and this may be something that your comment touches on, John, one of the mistakes is that there are too adversarial or confrontational in their mediation statements and in the positions that they take in the mediation. But mediation's a different ballgame than going to court. You're not there to beat up on the other party. You're not there to win the case. You're there to resolve the case in some fashion. And a mediator can help get the parties into that frame of mind.
I would think that, getting people to the room can be often the biggest challenge. What advice would you give to litigants when they show up in the room, or the virtual room as it might be right now? What advice do you give them for the most successful process?
Well, the most successful process is to get people on track to some kind of a resolution. And as a matter of fact, I'm glad you mentioned the virtual room, because one of the advantages that has come out of people mediating remotely is that it's so much easier. You can stay in your office. You can be in one place, your client can be in another place, and the lawyer and the parties on the other side can be in different places, and the mediators in a fifth place. And yet you can have a candid discussion, and the mediator, generally as the host of the mediation, can move people around, can put people together in a way that's really a lot easier than where you're dealing with a in-person mediation. Now, there is still something to be said for face-to-face discussions, for, as I call it, grabbing the lapels and fogging the glasses of the parties. But a great deal can be done remotely, and I frankly have been surprised that remote mediations work as well as they do. But they do.
So, Judge Walker, one of the things that's interesting, I think you maybe alluded to this earlier, is when people go into mediation, they're in the mood to get the case settled.
Well, not always, John. Let me interrupt you there, right there. Not infrequently, they go into mediation because the judge has told them to go into mediation. And that is generally not a very good sign, because at least one side, and maybe both sides, don't really want to mediate, don't really want to move toward a settlement. They'd rather litigate or continue to litigate until some issues get developed, but they've been essentially strong-armed by the judge to go into mediation. When the judge says, have you thought about settlement in this case? Have you picked a mediator and so forth? The lawyers are very reluctant to say, no, Judge, we just don't think it's time to mediate this case.
Right.
I wish lawyers would do that more often, but they don't. And so sometimes they come into a mediation because they've been basically told to mediate. That's generally not a very positive development. What can be done, however, to deal with that is for the mediator, once the mediator sees that it's not likely that the case is going to settle in the present posture, is to tell that to the parties, send them on their way, and sometimes get the permission of the parties to tell the judge, we've had a session, the case is just not ripe for mediation at this time. I've told the parties I'm happy to deal with them in the future if they want to come back, but now is just not the time. So sometimes the mediator can say something to a judge that the lawyers would not say to the judge himself or herself.
And Judge Walker, I've heard the term a mediator's proposal. Do you ever use that technique? Could you tell us what that is and how that can be used?
Yes, I've used that a number of times.
You and I may have used that together in the past, truth be told. But.
Well, yes, and generally successfully. You have to be somewhat reluctant because to make a mediator's proposal, because once you make a proposal, it tends to exhaust your neutrality, because you generally have taken a position on what the outcome of the case should be. But for the most part, I found mediators' proposals are often successful. Only once, I think, did I make a mediator's proposal over the objection of one of the parties who said, no, please do not make a mediator's proposal. But I wanted to get on to another event. That day I made the mediator's proposal and the case settled. So But a mediator's proposal is simply an evaluation by the mediator after a day or several days or weeks, whatever it happens to be, of the mediation process, in which the mediator explains what he thinks is an appropriate way to resolve this case, proposes that to the parties, generally on what is called a double-blind basis. That is, if one party accepts and the other party does not accept, the mediator simply says the case is not settled. And the party that did not accept is not aware of whether the other side accepted or did not accept.
That I agree with you. That does seem like sort of almost like one of your last moves that you want to make. But it can also be really effective, I think, if in helping the parties understand if they have a different view of the value of the case, getting a real sort of hard view from a neutral third party about what they think. It's not necessarily, I don't think a mediator's proposal is who's going to win and who's going to lose. It's more of, here's how I evaluate the risks, and where my sense is, the correct weighing of the risk comes out.
Sometimes the lawyers will ask, well, what do you think the judge is going to do with this matter? Is he going to rule on that motion? How is he going to rule on the motion, or she's going to rule on the motion? That can be pretty tricky as well. Inevitably, what happens when you do that is you say, well, I think that's a pretty long shot for you. And the lawyer that you've given the bad news to says, oh, we like our position. We like our position very well. So that can be a tricky business as well.
I wanted to ask about that. It's kind of a wild card, but bear with me. So we recently interviewed Professor Josh Davis from USF School of Law. And in that interview, we discussed the possibility of using artificial intelligence in mediation, specifically with perhaps giving parties predictive outcomes on their arguments or their positions. Have you ever heard of artificial intelligence being used for that reason?
Yes.
And have you ever encountered it?
Yes. And in antitrust cases and other types of cases as well, it can be extremely useful in determining what are the factors that establish the liability issues and the damage issues. One of the more promising developments in the last few years is, in these complex cases, the establishment of a common website in which all of the documents associated with the case, all of the depositions, all of the discovery materials and so forth is accessible online. Sometimes that will be segregated so that there can be a plaintiff's room and a defendant's room and so forth. But having all of that material in one location allows the information to be evaluated, sliced and diced, as it were, in a way to identify important factors that contribute to the liability determination and obviously the damage determination. I've been told by people who know far more about artificial intelligence than I do in this context that it won't grind out an answer. It's not like putting in the data and out comes the answer to what the outcome of the case should be. But it begins to focus on those factors that are determinative of the crucial issues. And the power of the ability to process all of this information is quite astonishing and very, very helpful.
Yeah, I would think it helps people at least, get past certain issues that they've been, holding on to. So at least it's another tool that can help move the process along.
It can be expensive, but I think it pays off.
Just what are some of the mistakes that lawyers and litigants make in going into the mediation? And by that I mean both not taking advantage of the mediation process, but also perhaps even making the mediation counterproductive. What are some of the things lawyers and litigants should avoid?
The most common mistake, John, is lawyers being too adversarial in the mediation. Expecting the mediator to go into the other room and beat up on the opponent. Generally, the mediator cannot do that very effectively. It's true the mediator can talk to the other side about the weaknesses in the other side's case, but the mediator is going to talk to you about the weaknesses in your case. And frankly, one of the benefits of mediation, even in a case that doesn't settle, is having that conversation. One of the things it does for a lawyer is it has a third party come in and tell the client what the bad news is, that perhaps the lawyer has been reluctant to tell the client or has mentioned to the client but kind of sugar-coated it. But if it comes from a third party who's disinterested, that can serve as a wake-up call for the client. So that's one advantage that a mediation can yield, even in the event that the case doesn't settle at that particular mediation. And one of the other mistakes that is common, not quite as common, but it is nevertheless frequently observed, and that is expecting the case to settle in one mediation session. Scales do not fall from the eyes in one act, necessarily. Sometimes it takes a while to digest information, and people have to go away and think about things and maybe do a little more litigation and so forth and come back. It's a process. Mm-hmm. And a process often takes time. And you can't rush it. It's like a cake in the oven. You can't take it out too soon. And if you leave it in too long, of course, it gets pretty dry and stale. So you want to try to time it right. But it does take time sometimes to get particularly these complex cases sorted out.
And I mean, so I think that's good advice. I mean, I think what I'm hearing you saying is you need to be patient. Yes. You have to manage the expectations.
Very definitely.
Mm-hmm. In terms of, is there such a thing really as advocacy before the mediator? In other words, if you're being an advocate to the mediator, are you doing the right thing in a mediation?
Not really. What you need to do is, in a dispassionate way, lay out what you think are the strengths of your case and the weaknesses of the other case, without rhetoric, and have some evidence or some law to back up your position, so that the mediator doesn't get the impression that you're just pounding the table, that you actually have something that is going to resonate with the judge in the case, or a jury, depending upon what the circumstances are. But a calm and dispassionate presentation to the mediator is very helpful. And oftentimes you can introduce some of the practicalities. If you're representing a defendant with limited financial resources, you can make that case to the mediator, perhaps in a way that you'd be reluctant to make that case to the other side. And the mediator can use that information and perhaps suggest some ways to work out the matter in a way that wouldn't necessarily disclose information that you'd prefer not to be disclosed. But there are things you can tell the mediator that you just are very reluctant to say to the other side. And the mediator can use that information, maybe not directly, but can use it in terms of moving the dialogue further along.
Now, Judge Walker, I'm going to ask you a question, and I don't mean to have you reveal your secret sauce here, but what are some of the creative ways that you have been able to get the parties to a settlement? What are some of the creative and interesting techniques you've used yourself to get people there?
Well, mediators' proposals are obviously a pretty powerful tool, but as we've discussed previously, they have to be used at the right time and in the right way in order to move parties. And probably the other way is, I don't know that it's so creative, John, but you need to identify who the decision makers are. Sometimes it's the lawyer, sometimes it's the party, sometimes it's one of the persons in one room and the other person in the other room. And you need oftentimes to get the people who can have a dialogue together outside the presence of the others. That's one of the advantages of remote mediations. You can identify the decision maker in one room and the decision maker in the other room. Try to figure out whether they're able to talk to the decision maker in the other room. And if you get the sense that, yes, these two people can have a dialogue, put them together and see what happens. I've done it successfully, and I've also done it, and it hasn't worked. So, but you do need to kind of slice the parties up and get the folks who you think are most amenable to moving the case toward a resolution and get them talking.
And in my experience, sometimes that means moving the clients out of the room and talking to the lawyers. And sometimes it means moving the lawyers
out of the room. Exactly. That's exactly. Sometimes the lawyers are an obstacle. But generally, one of the pleasures of working in this field is the lawyers tend to be very good and very professional. So you don't have the problem associated with the lawyer of marginal ability or marginal incompetence.
Let's talk a little bit about class action, mediating class actions. So is there anything special about the subject matter of antitrust class actions that makes it particularly easy or, on the other hand, difficult to mediate? And I guess my follow-up question would be with regard to who participates in those mediations out of the class or their counsel. And, how do the mechanics go with these types of mediations?
In a class action, there's a party that's not in the room that's an important player in the process, and that's the judge, who's going to be called upon to approve the settlement or not. And it's very important for the parties to realize that, to understand that, and to put together a settlement that the judge can approve and can feel good about approving. That is to say, it needs to be a settlement that resolves the case in a manner that is consistent with the facts and the law that have developed, a practical evaluation of those criteria, and so that the parties who are going to be presenting the proposal jointly can, in good faith, say to the judge, this makes sense from both sides of the case. That's an important factor. Once in a while, there are circumstances in which the mediator can interface with the judge, but that's a very delicate matter. Very delicate indeed, and most judges are pretty reluctant to have any discussion with the mediator other than a plain vanilla, yes, we mediated and it worked, and you're going to get a settlement proposal, or we mediated and it didn't work, so you're going to have to carry on with the case. Other than that, and oftentimes you don't even have that kind of a dialogue with the judge. But in terms of describing the process of the mediation, that's really not something that should be imparted to the judge other than by the parties themselves. I did do a little backroom maneuvering in a case several years ago. It was an antitrust case. There was a motion pending before a judge. I didn't speak to that judge, didn't speak to anybody in that judge's chambers about what was going on, but it was a important and decisive motion that was pending. Now, I thought I knew how it was going to come out. One party, I thought, was sure to lose that, but there obviously are risks on both sides. In any event, through an old pal on that same court, not my home court, but another court, I got some information about where matters stood on that motion in the judge's chambers. Didn't disclose it to the parties, but kind of hinted and suggested that they ought to be thinking seriously about what they ought to be doing in this. Oh, no, we're quite confident about the outcome. And so the mediation adjourned, and boom, the order came down, and it was case dispositive. But that's a very tricky business, Kayla, and you don't do that except under very unusual and circumstances that are quite different from the usual.
Is there any stage of the case in terms of class actions of when it's the best time to mediate the dispute?
The best time to mediate is when there's enough information on the table so that people are able to make an appraisal of what their prospects are. When that is, depends on the case. There has to be enough information on the table so that parties are able to see what the parameters are of a trial outcome. And that generally means there has to be a fair amount of discovery, oftentimes a fair amount of motion practice. In this field, the antitrust field, the law is certainly not entirely settled. There are a lot of unsettled questions, and oftentimes those are important in these cases. But you're not working from a blank slate, and you can pretty much figure out what the legal issues are and how they're more likely than not going to move. But there has to be enough factual information developed so that can be evaluated in terms of what the law is. So
Judge Walker, I want you to settle a bet.
Okay.
Last year, Megan Jones came on the program, and she and I had a bit of a debate. And one of us took the position that the best time to settle is when you've seen some motions, and when, for example, summary judgment has been decided or motions to dismiss have been decided, and there's been some data that you have about actual motions being decided. The other of us took the position, no, the best time to settle is when everything is up in the air, when you have enough information, but when there's enough uncertainty so that you can use that uncertainty to kind of bridge the gap. Who was right?
You were right.
I'm sorry, say again?
You were right. You were
Which side was I?
Well, I understand you were saying you have to have developed enough information. There has to be enough motion practice, enough discovery, enough to allow the parties to figure out what the prospects are. That's clearly the best time to settle. Now, a lot of judges will see a case for the first time and kind of roll their eyes and say, why in the dickens doesn't this case settle? And that's when they oftentimes force people into a mediation too soon. But the best time to mediate is when there's been enough case development to allow parties to know what they're dealing with.
And I think you probably are agreeing more with Megan Jones then, because
is that right?
Yes, because what the disagreement was she said exactly what you said, and said, but the parties need to know the outcome of certain motions. And my view is like, look, if you have a summary judgment motion pending, the best time to do it is when everybody is uncertain of how that outcome is, because once if you get to that certainty, you've just lost something to debate.
Well, if you don't know, if it's highly uncertain, then you're shooting in the dark. Now,
Megan Jones wins again.
Well, in any event.
Last question for you, Judge Walker. Can you tell us a story about a mediation you did that was fun and came out with an unexpected result?
Well, I think I've already alluded to one, and that's one where I made a mediator's proposal over the objection of one of the parties. And I thought I was kind of frustrated and anxious to move on and conclude the matter. And we'd been going all day. And I just said, folks, I'm going to make a proposal and take it or leave it. Did, and they took it. I frankly was surprised at that outcome, but it worked.
And what was the event you were trying to get to?
A dinner that came up unexpectedly. It was purely a social event. I got a call during the mediation. Hi, we're in town. We'd love to have dinner with you tonight. Are you free? And I thought, this thing could go on till midnight. And I was just not going to let it go on to midnight. I was going to go on to that dinner. And so I made the proposal and it worked.
But so, and Judge Walker, I'll tell you my story. One time I was in a mediation and we learned that the other side's lawyer had dinner reservations at a very, very nice restaurant at, say, 7 p.m. So we spent the entire day kind of staring at each other and not really moving a whole lot until about 3 p.m. And we knew that lawyer was going to want to settle prior to 6:15. So we think the dinner reservations got us a better deal, but we're probably wrong. But we just like to say
I know. Anyway. I don't know. Maybe so. Lawyers and parties are human, and they have life. The lesson, I guess, is life goes on, and litigation is not the end. There's a writer here in San Francisco, Ambrose Bierce, who wrote some years ago that death is not the end. There remains the litigation. And the problem is litigation can go on interminably if you let it. But life has to go on instead.
To a point you made earlier, we've done it all different ways, right? On the one hand, I do believe that if you get people who are willing to be in a mediation, they're in the mood. So striking while the iron hot, there's some advantage to that. But at the same time, we've had sessions where it's gone through, it didn't work out, and it just took patience and follow-up calls and just sticking with it. So I guess, there's no one size fits all.
No, there really isn't. And I say fortunately, and what makes it interesting is there's always a bit of psychology in it. People are people, and it's not just cut and dried legal and factual matters.
And it sounds like people should put their best offer forward on a Friday afternoon when everybody's hungry.
And that's my strategy, Kayla. Now you've revealed my secret sauce. Judge Walker, why don't we shift gears a little bit? Do you have any advice for younger lawyers who would be interested in practicing in the antitrust area? What are some of the things that they should do to position themselves and to get the experience they need?
Well, if they're already interested in practicing in the antitrust area, they've learned, I think, one of the most important lessons, and that is antitrust law is fascinating stuff. It's essentially industrial policy, which is very important from an economic point of view. It also is very closely tied into what's going on in the world, the advances of technology, how business is done. I think is just absolutely fascinating. And you get into a case involving some industry that you've never heard about or thought about or have any knowledge of, and you learn so much. It's quite remarkable. And yet it's at bottom, antitrust law is basically a common law doctrine or a series of common law doctrines. And it's developed in a common law way, which makes it so much more flexible and kind of common sense oriented than other areas of the law which are rooted in statute and regulation and so forth and are cabined much more severely. But there's a flexibility with antitrust law that adapts to certain circumstances, some of them political, some of them economic, that makes the development of antitrust law so very interesting. So if the young lawyer is already interested in antitrust law, that's always the first step, and it's a good first big step. What to do as a young lawyer interested in the field? Best advice that I've ever heard offered to a young lawyer is the best way to advance your career is the work on your desk. Do a good job on what's before you, and it's remarkable how a good job in one case or one aspect of a case leads to more work and more interesting work and greater work. There's no magic to it. There's no shoe shine and smile or personality. Personality, of course, all helps in all walks of life, but doing a good job and being cooperative with everybody that you're involved with as much as you can goes a long way. So
I had a mentor once tell me that the best marketing presentation you can make to a client is winning a case for them. So it's the same sort of thing.
Yes, that's obviously true. But I must say I had an experience where we lost a case and developed a very satisfying client relationship. The client thought we did a good job, and so it's doing a good job, I think, even more than winning, because sometimes you go into a case, the facts are stacked against you. It's very tough, and a savvy client will recognize those circumstances. But once it's day in court, and if it perceives that you've done a good job, the outcome in many ways is less important in the long term than how you handle the case.
All right. I think we're running up against time. So let's go to our final segment, The Curious Hat.
And now it's time for The Curious Hat.
Judge Walker, when we're together, we have a hat in our studio and we give the hat to the guest. The guest chooses a question. They ask the question. Since we're not together, I have a list of the questions in my hand. I'm going to ask you to choose a number from 1 to 25. I will read you the question that corresponds with that.
Okay. How about 14?
Okay. Number 14.
I was going to say 12 and a half, but 14 is pretty close.
Yeah. Okay. What did you wish you knew when you started your career?
My career as a mediator, or my career as a lawyer, or
your career? Let's say your career as a lawyer.
I wish I knew how interesting it was going to be. I did not set out to become a trial lawyer. Didn't think when I began practice that I was going to remain a lawyer for my entire career. But I started doing it. One thing led to another, and it was interesting. And pretty soon, nearly 50 years has passed. And so maybe it would have been a bit of a disappointment if I had known how long it was going to be. But no, I've been very satisfied with being a lawyer, then a judge, and now a retired judge. I tell people who ask, how do you become a federal judge? And I tell them, well, no, you don't really want to be a federal judge. What you really want to be is a retired federal judge, because that opens up more interesting doors than even being on the bench. And being on the bench is fascinating because no matter what's happening in the world, over the transom will come a case that touches on something that's going on in the world, and you feel very much a part of what's happening in the world. What you don't see as a judge is what's behind the screen and what's going on that's led to that. But doing what I'm doing now, you're privy to that information as well. So I think it's the best career of all.
Judge Walker, thank you for joining us, and we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.